purpose of copy. Thank you very much, Your Honor. Your Honor, we are so disturbed by the manner in which the state is handling this matter. Just as a joke, Your Honor, because they did come before your sister, Honorable Susan, Your Honor, with a miscellaneous application and custodial orders were given. They requested for 14 days, and Your Honor, 7 days were given. And the court, in its own wisdom, believed that 7 days were sufficient for the DCI to conclude their investigation and charge one Bob Njagi. And then again, Your Honor, today we are being treated with infertile imagination. There are further days given time, and they are not even telling you the amount of time that they require, Your Honor. If you want to know that the DCI is a joke, Your Honor, you are told that give us days.
We will not use those words. So refer to state agencies.
Your Honor,
I'm not clear.
You are clear.
Okay.
Your Honor, you are being told that we need more days. We don't know until when, 2050, 2100, how long do investigation? Your Honor, please come. This is a court of justice. And don't let there is no, the doctrine of specificity. They are not specific on what they want, but they are just telling us that they want to investigate. Your Honor, the norm should always be arrest, should always be investigate, make arrest, arraign. Then they are starting with arrest, put in the custody, then investigate. Your Honor, that is not the order of doing things, because that is infringing and violating on serious constitutional principles. Your Honor, there are violations which states that an arrested person to be informed promptly he best understands of the reason the arrest was made. According to this case, Your Honor, because even the DCI is not sure of what to charge, of what charge to bring forth, and is still under investigation, it therefore means that the arrested person was not informed of the reason why he was arrested And that amounts to abduction, Your Honor. Article 50 of the Constitution, Your Honor, on a right to a fair hearing or trial, Your Honor. This right cannot be limited, Your Honor, under Article 25C of the Constitution of Kenya. The Constitution does not treat this right as a procedural luxury, but instead it treats it as an indispensable pillar of justice. And Article 25C of the Constitution declares this right as a non-derogable. Right that must survive political tension that is being treated before us. Because Bob Njagi was arrested on the 24th day of June, just a day before the maandamano, which is also enshrined, allowed in the Kenyan Constitution, right to picket and present petitions. It must survive political tension, public outrage, and even state of emergency, Your Honor. And this right cannot be suspended, it cannot be diluted or sacrificed at the altar of expedience, Your Honor. Further, Article 50, subsection 1, Your Honor, of the Constitution guarantees every person the right to have any dispute determined in a fair and public hearing before an independent and impartial court. Your Honor, justice is not merely about arriving at a conviction or acquittal. Justice is about ensuring that the road to that decision itself is fair. Therefore, Your Honor, this court must jealously protect this right. Your Honor, the state possesses immense investigative machinery, unlimited resources, and coercive powers. The accused person standing before you, Your Honor, only has the Constitution to protect him.
He is not an accused.
The arrested person standing before you, Your Honor, only has the Constitution to protect him. But according to the DCI, he is already convicted, Your Honor, according to the way, the direction that is taking. Your Honor, I want to talk to you about administration of justice, Article 159. This court is not merely a forum for determining disputes, Your Honor. It is the constitutional custodian of justice. Every decision rendered by this honorable court either strengthens or weakens public confidence in the administration of justice. Article 159 of the Constitution provides that the judicial authority is derived from the people, and shall be exercised in accordance with the Constitution of Kenya. And the judiciary therefore exercises power on behalf of the people, not on behalf of the executive, nor the legislature, or any other private interest. The administration of justice is not measured by the number of convictions, Your Honor, number of convictions secured, or applications dismissed. It is measured by whether the process is fair, impartial, transparent, and faithful to the Constitution. Your Honor, justice administered under pressure ceases to be justice. Justice administered in fear ceases to be justice. And justice administered to satisfy the state also ceases to be justice. The Constitution of Kenya only requires only one standard, which is the constitutional justice, not any other. Therefore, the duty of the court is to validate actions, is not to validate actions of the state, Your Honor, merely because they are popular, nor condemn an accused person merely because of allegations such as this, just to attract public attention. The administration of justice demands fidelity to the law, equality before the law, and unwavering protection of constitutional rights. That is the promise made to every Kenyan by the Constitution of Kenya. Article 159, subsection 2, Your Honor, states that justice shall be done to all irrespective of status. It shall not be delayed, Your Honor, which is happening in this case. It shall be administered without undue regard to procedural technicalities, and the purposes and principles of the Constitution shall be protected and promoted. These constitutional commands are not aspirations, are not aspirational, Your Honor. They are binding obligations. They require this court to ensure that justice is not only done but is manifestly seen to be done. And Your Honor, history does not remember courts that merely followed the prevailing winds of the day. It remembers courts that upheld the Constitution when it mattered most. The legitimacy of the judiciary rests not on the popularity, but on the unwavering commitment to the rule of law. We therefore, Your Honor, respectfully urge this court, Honorable Court, to administer justice in accordance with the Constitution, and influenced by external pressures and to reaffirm that in Kenya the law remains supreme over power. Your Honor, the court exists not to ratify power, but to restrain it, not to echo the loudest voices, but to uphold the Constitution. And therefore, lastly, Your Honor, every judgment, every ruling delivered by this court is a statement about the kind of a republic we aspire to be. Today, Your Honor, humbly ask the court to let that statement be one of justice, courage, and fidelity to the Constitution. Your Honor, we also request humbly, as you close the file, Your Honor, we humbly request that the gadgets, the phones that were taken away from Bob Njagi be returned to him, Your Honor. All this is against the spirit of the Constitution, Article 50, subsection 2, paragraph L. But he cannot self-incriminate. And authority to that effect is Wilmington versus the DPP in the UK, 1935, AC 462, where Judge Viscount Sankey stated that the burden of proof lies solely with the prosecution, not the arrested person. So he cannot help the DCI officers to investigate himself. Therefore, the Constitution solely expressly protects Bob Njagi from being compelled, directly or indirectly, to furnish evidence that may incriminate him. Because the burden of proof, proving this case, or the charge will solely rest on the prosecution. Thank you, Your Honor.
Are we done with your team?
Yeah, I don't know unless it is also